Welcome back to Debt Savior. It's your host, Jack McKay. Hey, we're back to this is step 7, small claims, the small claims cases. Okay, let's go through this. You're going to do 4 small claims lawsuits. Okay. 1, In God We Trust USA Inc., 2, FDCPA, 3, SCRA, 4, state version of the FDCPA. And then really, at the end, I'm going to show you that you can actually do more than 4 small claims cases. Once you get these 4 down, you can do other ones, and we'll talk about that at the end. Okay, here we go. Note, for all of these lawsuits, one can fill out a form to waive the fees for filing a small claims claim. In each state, this form is named different things, but the purpose of the form is to have the fees waived for filing lawsuits. 2 examples of the name of this form, the states are indigent form, another is a waiver of fees form. We went over this at the end of last video. Okay. If you operate a trust as is recommended and do not operate your person, then there are no financials for your person. So all the answers to the questions on this form would be 0 for an amount. Remember, we were just talking about this form, remember? Right here, application. Okay, we talked over that, right? Zeros, right? For example, if it says an amount in a bank account, 0, right? As previously mentioned, operating a trust allows one to file as many lawsuits as needed for free. And that is only one minor benefit of the trust. I just want to bring it up here because you don't want to spend a penny on, it can cost a couple $100s for each one of these cases. You don't want to spend a penny, right? Don't. Okay. And, set your assets up so they can't get anything. That's the trust too. So before you start this, you want to have everything safely tucked away and do it for free against them and show you don't have anything they could ever win. I mean, what could be better than using this trust? Okay, let's keep moving on. Filing a small claims case and waiver of fee form together lets the defendant know when they receive service of process, right, that they get your mail about this lawsuit, that their upside at most they can win is $0. Defendant will understand that they will not make a single dollar no matter how any lawsuit goes, win, lose, or settle. This inevitably deflates any opposition since no gain is possible for the defendant. Yes, it disincentivizes them, right? Okay. For a small claims case itself, there is a 1-page filing to initiate a small claims as plaintiff in any state. Okay, we talked about this form, right? Now let's go on to, whoops, I know I have it pulled up here. Okay. So an example, Sarasota County, where I have done filings and small claims, you can go to your county website. There's going to be instructions for small claims right there. Here they are. Look at it, right? And, if you look on it, there'll be something about the forms, right? I looked up forms. Small claims forms I looked up. I Google searched. And look, it has them. Then I clicked on this. Generic statement of claim form. Okay. Here it is. This is a really easy 1-page form in every state and every county. Small claims is super simple. That's why it's great. And with the trust in that form, you can do it for free. Okay, so what's going on here? I want to see that. Okay. Here's where you write in plaintiff. That's what, your person's name and all that. Versus defendant. This is the, whoever says they're owed money, right? They go in there. Statement of claim. It's very simple. You're going to sign this BY colon and then sign, right? This is an action for damages that can't exceed $5,000. Great. A lot of people say, well, my mortgage is way more than $5,000. Why would I do small claims? I don't get it. Well, you're not suing them for the money in here. You're getting them in the courtroom to see if they have the paperwork, right? And you're using a trick to get them in the room. right? Small claims is super easy and free to get them in the room. Then you're talking about, this whole debt, and you're like, so do you have the paperwork? Do you have the originals? Well, and if they don't, you have an action that says, well, they don't have paperwork. So why would they continue on with a mortgage if they don't have the paperwork? Do you see? So it's a trick to get them in the room. Maybe get some money out of them, too, in the process. Anyway, this is the form. It's a super simple form. It's slightly different in every state. Okay, let's go back with this, all right? One-page filing to initiate a small claim, says plaintiff in any state, okay? This form is usually called a statement of claim. Your person is plaintiff and the liar banker is defendant. The defendant's address is determined by the Service of Process rules for your county's small claims filing procedures. Sometimes the address can be their corporate office, and sometimes it has to be a registered agent or either. Like in Florida, it can be either one of those things. So that's why you want to be doing certified mail with the mailings you've already done, because you already have a good address for them. You already know what they accepted certified mail, so you know how to get them. Service of process, that's what we're talking about here, okay? Okay, let's continue on here. To find out, which address to use for the defendant, check online on your county's website for small claims filings, or call the clerk of court for your county and ask if the website is unclear to you. What address has to be, you can ask the clerk of court or look on the website. If you don't understand, just go down and ask them. It will tell you the rest of the information for filling out the statement of claim, which is really basic information like name and address. The empty box where you write the reason for the claim is what the following information will explain in detail. See, most of this is just easy, right? And then you got an amount and a box. And so that's, it's a super simple form to do small claims. That's what we're going to talk about next here. In the numbered paragraphs directly below each small claims filing, as far as what you put in the empty space for the reason for the filing, right? So this is like these words right here, would go in this box. Now wait a minute. You're like, wait, that can't fit in that box. Okay, well in the case it doesn't fit in the box, you just write the words see attached. Right? See attached, S-E-E, and another word, attached, right? And then you attach a piece of paper that would have this written on it, right here. And so that's your statement of claim, this right here. You just copy, paste onto a piece of paper and says, see attached, this is what you attached, okay? Just remove the one, and you just copy this, and that's it, okay? So let's go through it. Well, actually, I'm sorry. Yeah. It's pretty simple. Let's go through it, though. Okay. Plaintiff is not licensed to do business as required by Florida statutes, Title XXSII, right? Let's look this up. Copy this, go over here. Florida, this is their statute right here, licensing, right? If you're going to be in trade and investments and solicitations like banking and any of that stuff, you need a license. See, right here. Every state has some similar law that if you're in, some kind of investments in business and commerce like this, you need a license. So you gotta look it up in your state. This isn't, or you can just remove this, but see, this is the state law that shows why you're bringing this action in the court. So you need a state law to do this action. All right, here's the one it is. Any numbers look familiar here? 33. Okay. So we just looked it up. So defendant is not licensed. See, that's just saying they need a license if they do this stuff. Use dollars, right? This is about the In God We Trust. This is about using dollars and them not being registered to the Secretary of State. They need a license. If you're going to use dollars, right, and be a trust and engage in all this commerce and stuff, that Florida statute says you need a license. So you ask, where's their license? And this is how you ask. Defendant is not licensed by the state of Florida, so you say what they're not doing. And is not registered to the Secretary of State of Florida and has no registered agent in Florida. All of which prove the defendant only engages in illegal activity in the state of Florida. The defendant is acting as an unlicensed, unregistered agent of the In God We Trust /USA Inc. See attached Exhibit A and B. What are those exhibits going to be? One exhibit is going to be In God We Trust, right? This information, you simply go and print this out from this website, right? This is information about the In God We Trust, right here. There's the URL. There it is. You copy, you print this out. This is one of the exhibits, okay? What's the other exhibit we're talking about in here? Exhibits A and B. And you can write Exhibit A on the top of this and Exhibit B on the other one, which is what? You would hand the clerk of court say a $20 bill and say, I need a copy of this for an exhibit. Can you make a copy, please? So they make a copy, and then you add it, a copy of that. Actually say, can I make 2 copies? Because you want to keep one for your records, right? And you add it to this filing. That is as Exhibit B or A. Okay, you write that Exhibit A or B on it, okay? And so what has happened in that process? One, you made a copy of a debt instrument, which you're not supposed to do, right? And neither is clerk of court. You're not supposed to make a copy of a dollar bill. That's counterfeiting, right? Making a copy of a note. But see, they bring a copy of a note into court to prove that, you're guilty of owing debt. So you simply do what they do. And, then you've got this copy of a note on record, and then you're showing exactly what you're talking about, the In God We Trust. Okay? All right. Those are the exhibits, which is itself, here we are again, okay? The In God We Trust USA Inc., that itself is not licensed to conduct business in Florida, nor is it registered at the Florida Secretary of State either. Simply put, dollars are actually In God We Trust /USA Inc. promissory notes and are used illegally in the state of Florida under all circumstances. And forcing the population of the state of Florida to use In God We Trust USA Inc. promissory notes fits the definition of domestic terrorism and slavery. Pretty straightforward. You aren't licensed to do business here, yet you make everyone do business with you. That's domestic terrorism. That's what that is. Okay. Notice to principal is notice to agent. Notice to agent, notice to principal. Any agent, to include anyone acting on defendant's behalf of either of these unlicensed entities, is equally liable for their principal's actions. Defendant has no license to originate, collect, or issue In God We Trust USA Inc. promissory notes in the state of Florida, colloquially known as dollars, which are ubiquitous, proving collusion and conspiracy at all levels of government and banking, as all banking uses these illegal banking practices, which are nothing more than an illegal financial pyramid scheme developed between defendant and In God We Trust USA Inc. See, if they want dollars, they're saying they owe them. They're saying they are a part of this trust. So that's collusion between them. You see? Domestic terrorism, they're involved, both entities, and the individuals who are from those entities. Okay, let's keep going on here, right? Right here. This claim provides ample evidence for the immediate arrest and conviction of all officers of defendant and the In God We Trust USA Inc. on charges of domestic terrorism and slavery. So The amount of claim is $33. Okay, let's go back up here and look at the form, right? Amount of claim, $33.33. There it is, right there, amount of claim. Or $33, sorry, no 33 cents. Amount of claim is $33 because, why do I have this in here, right? $33, that's the name of Satan. That's the symbol that means Satan, the devil, whatever. In God, we spin the W here. If a W spins to the left, it's a 3. If an E is capitalized and spun, 180 degrees to the left, you spin a W 90 degrees to the left, that's the 3. Spin it, a capitalized E, right, 180 degrees, that's the 3 too, 33. I'd go into the Freemason, capital G. That's the 33rd letter in the alphabet. 33 is a symbol. They use signs and symbols of Pythagorean numerology, right? 33 is a symbol that means Satan, right? The Lady Liberty. That's not Jesus Christ. You see, that's the devil. So anyone with a birth certificate in any nation, right, is a slave of Satan. So that's why I use the number 33. Because it sticks an arrow into the heart and lets them know right here, you know what they're up to. You see? That's why the dollar amount is that. You don't care about the dollar amount. You're here to talk about this whole domestic terrorism thing that you have proof of and present them with. You see? They don't want that in court. The amount of the money is nothing. Okay. $33 for illegally collected invalidated debt against the plaintiff. On the record, plaintiff requests the full amount of domestic terrorism fine of $1 million to be awarded to a charity of plaintiff's choice. Anyone in the judicial system that sees this evidence and does not stop this continuous slavery and domestic terrorism becomes equally liable for defendants' actions, both personally and professionally, and themselves become guilty of domestic terrorism and slavery. These two paragraphs right here are your statement of claim. See, you want to put that, it'll say see attached, and it'll have this piece of paper attached to it. So if the clerk sees it and they don't, these are officers of the court. If they see a crime, they're supposed to report it. This is evidence of a crime. Okay, and everyone that sees this piece of paper, they're supposed to report this. Domestic terrorism and slavery, that this is proof of. You follow? Okay. So you want to put those exhibits, A and B, on the record for sure. You could put other exhibits on the record, but you definitely want these two in this case. Really, those two and no more in this case, sorry. But those two and no more. You can, if you choose, put copies of the mail you already sent. First mailing, second mailing, third mailing. You would take copies of that, right, and have them each be an exhibit. You see, so you can add them to the statement of claim. And see, that's just letting them know how far you're willing to go and how much you have your ducks in a row. You got your indigent form, so they can't get anything. You have your mailings. You said exactly what you're going to do. They get a full understanding from this first item that they don't want to deal with you, okay? And they're going to try and wiggle around this, but see, there's no way around it. They're going to end up in a courtroom with you, and if they do come, and if they don't settle before this, it's going to be a closed courtroom, and it's just going to be you and them trying to work out something. They're going to try and scare you or whatever, and you'd be like, no, I'm with Jesus Christ, you can't scare me. So, if you have a trust, you literally are, and you can't be touched. Officers of the court are rendered mute and frozen in place when trying to chain me, and so on, in courtroom. God is all-powerful. Once you're under the trust, there's nothing they can do to you in the courtroom. I've been to the court 50 times at least, on 50 separate court cases in different counties. There's nothing they can do to you. They can't even physically touch you if you sign the trust that I have available, the Bulletproof Trust on the website. Okay, there's no reason to fear going to court. Okay. But they don't want this out. this information. So this is your first action, okay, at small claims. Okay, so do one. Do all of that, go get it done, and then if you're not in an acute situation, see how it goes, see if they want to settle after one thing. See, each enforcement step is a new reason for them to settle with you because you're being an aggravating giant pain to them, okay? That's why they don't want to move on with you, because everything you're doing is not only legal and just and right and all that, but exposes their whole system and also exposes them individually and their businesses to culpability. Like, if they don't do something about this, and if they just move on with this and let this debt stand, they become liable for this debt. Do you see? And that they can see that happening in front of them. So that gives them a reason to say, hey, maybe you don't want to go forward with this. You know, each step of the way, your enforcement is like reasons. They have to spend money. They have to pay off a judge or, you know, people in the system and talk somebody into this or that so they can do more of their illegal stuff. And see, that always puts somebody out when they do it. It's fine to put them out a little bit because they do that at court all the time. Everything's illegal. But now this is known. They know everything's illegal. You caught them. Totally their hand in the cookie jar in every detail of it. That's different than them just doing business as usual. You're totally exposing them. Okay, so that's the first court case. Go through that. Go through the small claims process. That's great because, see, this first one isn't about whether the debt's collected legally or not. It's whether their entity, their bank or whatever, can even operate in your state, which they can't, and which they can, you know, if they can collect dollars, which they can't. Okay, so we're not even up to, is their paperwork good on the debt, and so on. Do you follow me? That's not what we're up to. We're before that. You don't even have standing to be asking for these dollars. That's what the first one's about, okay? All right. And any statute about anything close to licensing and permits, it doesn't even matter how close it is. Just go find something in your state. You know, something. It doesn't even have to be a fine and nothing like that. Just anything, like any banking law at all. It doesn't really matter. People become picky, like, oh, it's got to be this. Now, this is a reason to push this in front of them, out into public where they don't want it seen. And you're going to notify them, I got this whole trap set, and you're never going to get a penny from me, not ever, and all I'm going to do is cause you great, giant problems. Okay? That's the first one. So go down there. Now remember, you don't like people don't like court. Why not? They go into court with copies and forgeries. You simply mailed them, asked them for proof, and they didn't have it. Okay, so now you're using the court system and everything that's there for free, you know, to enforce the laws and get rid of this problem. Why would you be worried about being in court? You're doing great. You're like, oh, thanks. You're being nice, you know, hey, I'm going to court. Great. This is great. It's free. I learned a lot. Before you go, if you have any trepidation about court, just go to small claims a couple days. And you don't need a case or anything. Just go in and hang out and sit down. Do it a few times until you're like, this is actually boring. This is just the same thing over and over again. Great. It is. So, you know, go down there, make time to do it until, you know, you're like, oh, this is just super simple. You don't know what it is. Maybe you've never been to small claims, but the forms are simple. The courtroom's simple. How it works is super simple. It's so that anyone can go to court, really. That's what small claims is about. But we're using it to our advantage to expose them. Okay? Okay, so that's the first one. We're going to move on here to the second one. The FDCPA violation, right? Okay. Again, it's going to be the indigent form and the small claims form, right? And you can add as exhibits these items. First of all, here's just an aside. You know, people are like, well, you know, FDCPA, it doesn't work because I got a student loan. Yes, it does. Here you go, read about it. Fair Debt Collection Practices Act. Here, read all about it right here. It's an act. It's part of the United States Code, right? And it's about, collecting, who can collect debt and how. You start looking into it and you realize, hey, part of that is validation of debts, You have to get debts validated, right? See? You have to have it validated. Okay. And then what's the civil liability under Fair Debt Collection Practices Act? This is more part of it. It's like, oh, any debt fails to comply with the provisions, right? They owe $1,000. You see? So the next case that you're going to do is FD. Oh, you write in that little box, right? Right here. There's where did that thing go? Little box here is just going to say FDCPA violation, $1,000. You could put for these words, for Equifax, and then a date. Okay, so let's run through this. I think this is something else here. Yeah. Okay, you can put these two laws as exhibits, right? This is validation of debts. This one, Fair Debt Collection Practices Act, right? You can get validation of debts, which is from the Fair Debt Collection Practices Act. Make a copy of this as an exhibit. You make a copy of this as an exhibit. There's $1,000, right? Then you make a copy of this. This is another law, Uniform Commercial Code, which applies to all business transactions on Earth, but certainly in the United States. Okay, presentment. Do you have the contract you say you have? Presentment. It's like, where is it? You got to make presentment of it. Where is it? Is that thing present? And then an instrument is a note. Did you know that? An instrument is a note. A note, like, Federal Reserve note. Okay, that's what we're talking about. And other notes, right? A negotiable instrument is a note. So you put this in there too. It's talking about, a negotiable instrument and what it has to be. It has to be written. It has to be this piece of paper. Like, where is it? You got to make presentment of it. You can't just say, oh, I have a copy. No, where is it? Give it to me. Pull it out. A negotiable instrument, you have to have it. Where is it? Do you see? Sorry, that's next. So this can be an exhibit. 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 4 exhibits. 2, FDCPA violation, just those words. And then you can say like, for Equifax, and then a date. What does that mean? Okay, so let's get through what an FDCPA violation is, right? You wrote a letter, and also included as exhibits can be your mailings here, okay? They can be exhibits into this as well, okay? So those are all your exhibits. And each letter would have Exhibit A or, each one of those laws, Exhibit B, Exhibit C. So you got a pile of exhibits that go in with this, okay? And this is your support material for why you're owed the $1,000. Okay, pretty easy. So, but what are you going to go in there and talk about in court about this? You bring up the law as well. Validation of debt said, they have to make presentment. Where's the presentment? Right? Oops. Where's the presentment of the negotiable instrument? If you don't have that, right? If they don't do that, there's no validation, right? They don't make presentment of a negotiable instrument, then there's no valid debt. It's that simple, you see? So, and if there's no debt that's valid, you owe $1,000. It's that simple. I wrote the letters, I asked for validation, they didn't send me any validation. These are the laws that say they have to. They owe me $1,000. You see? But it's all a trick. See, that's how you do it. That's FDCPA violation. So, and another exhibit you're going to need is a copy of your credit report. Put it in there, you know? And then you want to have tried to get a credit card or some kind of credit, you know? And you'll have proof that you got denied. And so you see, I got this on my credit report. I asked them if this is real or not. I tried to get credit. I got denied. See, I'm incurring damages here. They messed up my credit. I can't get credit. So you have all the proof that they owe you $1,000. You put all those things together for this, and they owe you $1,000. See, it's a great thing to overcome. So that first one was about the In God We Trust. You can't use dollars. Now it's like, oh, well, you don't have the proper paperwork, you see? To be able to collect. Your Honor, they can't collect. They owe me $1,000. They don't have the paperwork. And those are all the exhibits and the reason why and the laws, okay? Put them all in a giant pile with the indigent form and the statement of claim form for small claims. Here's your pile. Thanks. See you in court. They're like, oh no, like they got us cold again, you know. So okay, so there's the next one. Same kind of thing as we just went through. Fair Credit Reporting Act. It's another law that they're bound to. You would add these two again, presentment and negotiable instrument as exhibits, all your mailings as exhibits to the FCRA, $1,000 one. These are exhibits in this one too, okay? The last one and this one. These two are both exhibits. In other words, it's the same issue. They did not make presentment of the negotiable instrument, right? And you can put this in there too. So they didn't validate the debt. So, according to the Fair Credit Reporting Act, right? Here it is. They owe $1,000. And you can put this in there too. They owe $1,000 right here. Because what? It's still reporting to the credit reporting agency. That's one issue. The FDCPA is about, can they collect? Okay, we just did that one. This one is about, can you report? Can you report it? You see? And so again, this is going to be SCRA violation. You know, it's going to say for, you know, Equifax report and a date. Okay? And then that Equifax report is going to be a copy in there. It's going to be a part of it. Like if your social's on there, black that out because I can't go on a court record. It'll be a reason to deny your case. So, but everything else is good to go. And you can bring the original that you blacked out so the judge can see it. You bring originals of all the copies you have, right? You put it in the court, and you bring all that stuff with you, though. This is what I copied. They're like, oh, let me see it. Here it is. So, okay, so this one, they have violated, you know, I'm sorry, there's an invalidated account they're reporting, so that's the next violation. Okay. Now the fourth one, so it's again, just like this one, the same stuff. You're going to have all of these, like have the indigent form, right? And okay. So now we move up to this one. There's actually sometimes as a defense to these, an attorney thinking they're all smart, right? Because this is a federal law, you're bringing in a state court. They'll be like, oh, let's move this to a federal venue. And they'll spend a ton of money and a ton of time and file all these papers and move it over to a federal court. Oh, you don't want to be there. That's not small claims anymore. You have to know all this procedure and blah, blah, blah. It's not as convenient. So just dismiss it, right? If that comes up. Because what? And move on to number 4. Because every state has adopted basically the United States Code. They've adopted, oh, that works for us, okay? And they change it slightly. And they can't make it less restrictive, right? They can't be like, oh, now you can do stuff, you know, more than the feds say. No, you can't do that. But it can be more restrictive, right? It could be like, okay, you know, they're going to have an FDCPA version and an CRA version, basically. So basically, that's why I say they're 4, but there could be 5. There could be other state laws, basically, to bring them into small claims. But These ones in particular are your best bets because there's going to be the same law written as FDCPA in the state law of your state, but the fine may be different, or there may be no fine. But you want one with a fine, let's say instead of $1,000, it's $500. So this would be same everything, same law, same exhibits, same all that stuff for these two, but it would just be where you would write in, you'd write in the statute, not FCRA. You'd write in the actual statute, like I did up here for this one. Like you write in the statute right here. This is the law, okay, right there, like Florida statutes, Title XXXIII, and then you name it, and then you'd be like, oh, $1,000 or $500 or whatever. And then again, it'll be for the Equifax report dated and then the date. See, and you put that in here. All right? Because it's still just the same exact violation that they've made, right? All the same exhibits, the presentment, and all that. Your credit report that you tried to get some credit and you were denied, all that goes in there, okay? So it's just the state version so they don't move it to a federal venue, because as soon as you dismiss, they'll be like, you'll start this, they'll be like, oh man, beat us again, so, but again, you made them waste super much money trying to get it to a federal venue, which is perfect. So you could even dismiss it and come down here and do this one, make them spend all the money again, or you could move number 4 up to number 3 if they do that, and then just do 3 down as number 4, you see? Oh, we got you the state version, fine. If they don't settle then do the FCRA. Make them spend 5 or 10 grand to move it to federal court again if they're so stupid. Then just do the state version of it again, you see? So there can be more lawsuits here. Okay. Let's move on to here. So I think you got that all there, and how you do it, what you say, what the logic of it is, what all the laws are. Okay. Let's get through this. As previously mentioned, each small claims case costs the defendant a lot of money to defend. This works in your favor. Why? They have to hire local legal counsel, and if they decide to litigate, they have to manage the lawsuit and the legal team, which costs money. Since they can't make any money, and this could go on and cost them an arm and a leg in legal fees, the lawyer for the defendant becomes your advocate. Their lawyer will be the one to tell them they can't make any money out of this and that it will cost their client, the defendant, a lot of money with no positive outcome. You with me here? Here we are. In cases other than foreclosure, it is usually good to do one of these small claims lawsuits at a time. No rush, as the goal is to have them spend as much money on legal fees until their lawyer becomes your advocate and advises their client, the defendant, to settle the case or cases. Even if you don't win a lawsuit, it doesn't matter at all, since the goal is for them to spend money uselessly. The more money they spend on lawyers, the less likely they will be to continue fighting with you. Since bankers collect every debt illegally, you are always in the right and they are always in the wrong. There are never any exceptions to this. Enforcement makes their entire system of slavery and illegal debt collecting be exposed and forces the bankers and government to compound their illegal activities and shines a light on them in public. Since the knowledge of the system of slavery is what will destroy their system, they do not want to allow their system to be exposed. Okay? So what we're doing is pushing these small claims cases out there, exposing everything they do in public, and costing them a ton of money and a ton of exposure, and they can't get a penny out of it. There's no upside to them. Do you follow me? The small claims, they don't allow you to do this in every state. Like I know I lived in North Carolina and they would not allow this to come to court, period. They just, oh, you can't do that. For they would say an out-of-state business. They will allow you to do this, don't get me wrong. But if it's out of state and you're like, well, then see what you want to do is then send it to like a branch of a bank. So you may have some restrictions in some horrible banker-friendly states like North Carolina, that doesn't allow this to happen. But most states you can do these small claims in, okay? All right. And if in the case of North Carolina or some other state, another rare state, you can't do this action in court, there are many other enforcement steps. That's why each state or each situation may have some limitation on oh, well, this enforcement didn't happen perfectly or something like that. That's okay. We're building a mountain of proof and evidence and enforcement so that they eventually don't want to go forward. Just the whole thing mounts against them, okay? This is an important step. It's a big step, but it's not the only step. Okay? So, okay, keep going on. You're doing great.